Okay, good evening, everybody. Can everybody hear me okay? Is that coming through? Okay, well, welcome, and thank you all so much for coming to the International Studies Department's keynote event for spring 2020. My name is Dana Zartner, and I'm a professor here at USF, and I apologize in advance because I do have a residual cough, and it tends to come out when I'm talking, so sorry about that. And I would like to begin tonight with a land acknowledgement. And I would like to begin by acknowledging that we gather tonight on the unceded land of the Ohlone peoples, in particular the Muwekma Ohlone and the Ramaytush Ohlone, on whose ancestral land we come together this evening. It is incumbent upon us to remember that this city in which we gather was founded upon exclusions and erasures of many indigenous peoples. And I ask you to join me in acknowledging these communities, past, present, and future. We also honor tonight with gratitude the land itself and the peoples who have stewarded it, respected it throughout the generations. Now this responsibility must fall to all of us, and calls on us to learn how to live in a more respectful and harmonious way with this land we now inhabit for the benefit of Mother Earth and for living things for generations to come. Thank you. I also want to take the opportunity to thank the many, many groups here at USF who provided support for this event. A complete list of all the departments and programs is on the back of your program who provided funding to bring our wonderful speakers to campus here tonight. But I want to especially thank the Environmental Studies program and the Dean's Office of the College of Arts and Sciences for their extremely generous donations to this event and their support. And finally, and perhaps most important, I want to give a special thank you to Ariella Campisi, who's up here in the third row, who is one of our wonderful departmental administrators, and for all her work in organizing the logistics for this event. As many of you know, have put on events like this, it involves a lot of moving parts, and Ariella, I think we can all agree, did an exceptional job in putting all of this together. So thank you, Ariella. So I'm going to briefly introduce our topic for tonight and our panelists, and then turn it over to the experts. So beliefs in the rights of nature have existed for centuries, if not millennia in some cases, among indigenous communities, spiritual traditions such as Hinduism and Buddhism, and really for anyone whose worldview encompasses a symbiotic relationship between human beings and the natural world. And it comes in different guises and has different names. And for me, one of the best descriptions of this worldview is the Maori concept of Kaitiakitanga, which I did not say quite correctly there, but it's an idea that recognizes that human beings are within the concept of nature and not above it, and that we have a special relationship to serve as guardians and protectors of the natural world, as well as being in solidarity with the natural world. And as climate change impacts and environmental degradation have worsened, more people are working to explicitly recognize what for many has been implicit before, and that is the right of all living beings to survive and thrive for their own benefit, as well as the good of the ecosystems of which they are an integral part. Globally, this has come to be called the Rights of Nature movement, recognizing the legal personhood of natural entities as a mechanism for not only providing protections, but also for issues of sustainability and environmental justice. And we have seen in just the past decade a significant increase in recognition of the rights of nature around the world. And while grounded in different cultural beliefs and executed through different legal mechanisms, the recognition of nature as important for its own sake, and correspondingly, its right to be protected from harm, is more and more frequently part of the global conversations that people are having. We've seen courts in India and Bangladesh and Colombia hand down decisions protecting the rights of rivers and forests. Legislation in New Zealand and Bolivia and Uganda has protected individual natural entities such as forests and mountains and rivers, as well as entire natural ecosystems, and constitutional provisions such as in Ecuador, which give nature in all its life forms the right to exist, persist, maintain, and regenerate its vital cycles have become more common. Even here in the United States, which is often, as we know, notoriously difficult on new ideas like this, indigenous peoples have codified their respect for and interrelationship with nature across the country, from the Ho-Chunk Nation in Wisconsin to the White Earth Band in my home state of Minnesota, who recognize the rights of wild rice, the Ponca Nation in Oklahoma, and our own Yurok tribe here in California. As well, municipalities have also recognized various versions of a rights of nature, including New Hampshire, Pennsylvania, Colorado, Oregon, and most recently in Ohio, where voters just about a year ago now passed a citizen-sponsored Lake Erie Bill of Rights. Challenges, however, remain, and in some cases are very significant. Around the world, while recognition and the enactment of rights of nature provisions is increasing, the questions of effective implementation and enforcement are big questions that are left to be answered in many cases. Here in the United States, lawyers defending rights of nature laws in Pennsylvania and Colorado have either been sanctioned or threatened with sanctions by courts unwilling to entertain these novel legal arguments. And in the Lake Erie case, the Lake Erie Bill of Rights, which was passed via public referendum, less than 12 hours after the measure was passed, a lawsuit was filed declaring the Bill of Rights, or the bill, unconstitutional, and in essence arguing that farms, as corporate legal persons, have a right to pollute the lake, but the lake itself does not have the right to exist and flourish as a natural being. Initial hearings on that case were held just about 2 weeks ago, and there's no decision yet by the judge in that case, so we will see what happens. So there many questions remain on this issue, but there is no doubt that every effort that has happened so far has pushed the conversation forward, and conversations about the rights of nature are increasing around the world. And we are so lucky that with us tonight, we have a few of the people that have been leading the way. Each of our panelists has worked in different capacities and in different ways on the recognition of the rights of nature within their own communities. And so it's my great pleasure, I'm going to introduce them each to you briefly. More complete bios on each of them are in the program for tonight, although there's no way to capture all of their amazing tasks in one brief paragraph. But at the very end of the table to my far right is Gabriela Eslava. Gabriela is currently a candidate in the Master of Public Affairs and Development Practice program at Columbia University and a consultant with Red Cross Columbia. She is also a lawyer and was both part of the legal team and a plaintiff in the Columbia Supreme Court case, which recognized the rights of the Amazon and also recognized government responsibility to address climate change. To Gabriela's left, we have Christopher Finlayson. Christopher was a member of the New Zealand Parliament from 2005 to 2019, during which time he had many roles. Among other things, he was Minister for Treaty of Waitangi negotiations and led the Te Awa Tupua legislation recognizing the rights of the Wanganui River through Parliament to its passage in 2017. He retired from Parliament in 2019 and is currently writing a book and returned to the practice of law, and also just informed me that he's been doing a lot of traveling. Next to Christopher, we have Mari Margill. Mari recently launched and is the executive director of the Center for Democratic and Environmental Rights, and she was previously she led the International Center for the Rights of Nature at the Community Environmental Legal Defense Fund, and has assisted with the codification of the rights of nature in the Constitution of Ecuador, in a number of communities in the US, and in many other jurisdictions around the world. And finally, to my immediate right, we have Geneva Thompson. Geneva is a citizen of the Cherokee Nation and Associate General Counsel for the Yurok tribe. She's a graduate of UCLA's School of Law, where she worked with organizations such as the Department of Justice Indian Resource Section, the Natural Resources Defense Council, Earth Justice, and the Tribal Law and Policy Institute. And Geneva was one of the attorneys responsible for the adoption last year by the Yurok Tribal Council of a resolution protecting the rights of the Klamath River in Northern California. So each of our panelists is going to talk briefly about their work and their experiences with the rights of nature efforts in their communities. And then afterwards, we will open it up for questions and discussions. Thanks. Gabriela?
Thank you very much. I want to start by thanking Dana and Ariela for making possible to be here, and also the University of San Francisco for this invitation. I have two objectives today. First, I want to explain the content and the process of, the content and the process of the first climate change and future generations' rights case in Latin America. And I also want us to reflect on what rights of nature for the Amazon rainforest means. So as Dana already mentioned, legal systems have found different paths to reach the rights of nature concept. We have the constitution in Ecuador, the legislative process in Bolivia, New Zealand, I think it is also legislation. In Colombia, I want to make clear that we don't have any article in any of our laws that states that nature has rights. We don't have that. We have an article in our constitution that says that we have the right to a healthy environment, and that's it. So it's been through our judges and through the Constitutional Court, the Supreme Court, and other tribunals that we have this concept in our legal system. So I'll start with the different steps we follow for building this case. This case started as a climate change case. We were looking for the main causes of greenhouse gases in our country. And to our surprise, most greenhouse gases were not located in the overcrowded, polluted cities. Most greenhouse gases came from the most biodiverse region of the world, the Amazon rainforest. For the moment we were working on our research, we found that 36% of greenhouse gases come from the forestry sector, and 98 of those gases came from deforestation. That deforestation increased by 44% between 2015 and 2016. That's approximately 178,000 hectares in 1 year. So why is this important? Not only because deforestation and cutting down trees affects biodiversity of the most diverse region of the world, but also because it has a deep relation with other ecosystems in the continent and in the country itself. So we found that there is a Colombian scientist who is part of the IPCC, and he has dedicated his life to explain the relation between the Amazon rainforest and the Andes region. And he explains that the rain that is produced in the forest travels with the help of the wind. And when it reaches the Andes, it becomes the water that 70% of the population of Colombia drink every day. So if you cut down the forest, you are not only increasing the gases in the atmosphere, but you're also affecting the water cycle. And why is this important? Why should a judge be concerned about this? We wanted to show that climate change is a human rights problem, that the increasing temperature, the increasing rain, the decreasing rain in other places of the world, that the fact that we are going to face water scarcity in some places is related to vector-borne diseases. It affects our right to health, our right to access to water, to a healthy environment, to food. We wanted to show that in a legal case. That's why we created a group of 25 children, teenagers, and young adults from all over the country. We come from 17 different cities and municipalities. Four of them are part of the Amazon rainforest. So if you saw the previous map, the Amazon is like drawing a diagonal in Colombia's map. It's almost 7 states that are part of the Amazon rainforest. 4 of the plaintiffs live in the area, 2 of them are indigenous. And we wanted to show that climate change affects all the cities. This is a picture of the whole group. And to build a legal case, we needed to prove that there is an actual violation or a threat to rights. So we found that our government had at least 4 different commitments regarding climate change. 2 of them were international and 2 of them were national. The international commitments were the Paris Agreement, in which the government agreed to reduce greenhouse gases by 2030. We also had a joint statement with the UK, Germany, and Norway to reach zero net deforestation by 2020. This case was filed in 2018. So we told the judge we had only 2 years to fulfill that commitment, and the deforestation rate was increasing. So there was something that the government wasn't doing well. But also our constitution states that everyone has a right to a healthy environment and has the right to participate in the decisions that affect that environment. And lastly, each president presents to the Congress a national development plan. And for that moment, the national development plan stated that the maximum amount of forest that was allowed to be cut was 90,000 hectares. So the data we had was almost the double. But to build a case, for those of you who are lawyers, you know, or are starting to study to become lawyers, you know we have to answer many questions to the judges. We need to prove that we have legal standing. How can I prove? I'm from Bogotá. That's the capital, that's in the middle of the Andes. How can I prove to a judge that something that's happening in the south region of the country affects my life? How can I prove that it also has consequences to Yurshel, who lives in the island? How can I prove that that is going to happen 20 years from now? The increase by 1.6 degrees Celsius is going to affect my future life. Who are future generations? Who's included in that group? Can I say that one omission from the government is putting my rights under threat? Which is the best legal action to use? So we needed to solve all these questions. I'm going to explain briefly. We have this amazing action in my country. Its name is tutela. It is included in the Constitution, and it basically says that whenever one right is violated or put in under threat, any citizen can go to a judge and present a tutela, and the judge has 10 days to solve the case. And if the result is negative, you can appeal, and then the second instance judge has 20 days, because you are talking about fundamental rights that is under threat. So we use the tutela. And we explained that there were 2 levels in this case. First was the violation, the real violation to the right to a healthy environment. The judge could go to the official information that the Colombian government presents to the Paris Agreement and see how deforestation was increasing and how greenhouse gases were increasing. But there was a second level that is going to happen 20 years from now. We told the judge that life expectancy in Colombia is 72 years. So it is probable that I'll be living 20 years from now, and that my city is going to be affected by climate change, and I'll be living the consequences of decisions I am not taking right now. So that's why we use the tutela. Which evidence did we provide? As I already mentioned, the IPCC informs the documents that the government produces for the Paris Agreement, official information from the government that recognizes this as an issue, scientific papers on deforestation, and basically the arguments I already mentioned. We explain for each of the plaintiffs which rights were under threat. So in my case, as I already mentioned, I live in Bogotá, and the water I consume comes from the Páramo. That's the highest part of the mountain of the city. And there are some official information from scientists from different universities of Colombia that have explained the changes of climate change in the Páramos. So I present that to the judge. Our main claim was that we wanted our rights to be protected, and we also wanted the government to have an action plan to fulfill its duties before the Paris Agreement and the national constitution. We wanted an intergenerational pact for the life of the Amazon, and we wanted the judge to order the different municipalities of the Amazon to have an action plan to adapt to climate change. So we knew this case was really strange for a traditional judge. We didn't have judges in Colombia talking about climate change or future generations' rights. We had judges resolving cases on pollution and more tangible things, not climate change, not gases you cannot see that will have consequences that you are not sure. So we asked the judge to use some special lens when reading our case, and those lenses were part of our environmental legislation, and are basically 5 different principles. First, the precautionary principle, intergenerational equity, that's part of the preamble of the Paris Agreement, participation, child's best interest, and what resulted to be more important, the solidarity principle. There is an article in our constitution that states that every Colombian citizen has duties. As you have rights, you have duties. One of those duties is to act in solidarity. That's it. And we explained to the judge that solidarity for us as young people had at least 3 different meanings. Solidarity with those with whom we share the same time and space, solidarity with future generations based on the Sustainable Development Principle that is part of our constitution, and also solidarity with those other sentient beings that inhabit the planet and that are part of the Amazon. But we didn't ask for the recognition of the rights of nature because that is not part of our laws. So we didn't have ground to ask for that. So here are the 3 different levels we explained. And we lost before the first instance judge. He said that we should have filed a class action instead of a tutela. And we appealed, and the case got to the Supreme Court. So we didn't have to convince 3 judges, but 7 judges, that we had standing and that our arguments had evidence. So the Supreme Court granted our rights, but it ordered to have an action plan for the short, medium, and long term to stop deforestation of the Amazon. It ordered the creation of an intergenerational pact for the life of the Amazon, also the update of the land management plans of the different municipalities, and it ordered the environmental authorities to create an action plan to adapt to climate change. But what resulted to be more important is that the judge did not found in the current environmental laws of our country a way to protect the Amazon. So it based its decision in the only precedent we have in the country. In 2016, the Constitutional Court declared a river that is in the Pacific area of the country as subject of rights. That was the only case. And the Supreme Court said, based on what the Constitutional Court said, I declared the Amazon rainforest subject of rights. So what does it mean for this judge that the Amazon has rights? According to the decision, it means at least 4 things. First, it recognizes the Amazon as a living entity. It recognizes its existence. And also, it says that it has the right to be protected, preserved, maintained, and what I found most important, to be restored. And there is a part of the story that's really long, and I didn't tell, but in 2016, the Colombian government signed a peace agreement with the oldest guerrilla of the continent. And ending a war in that part of the country meant that many people who weren't able to go there are now able to access this part of the country. And that has increased the deforestation rate. So that's a paradox. You can tell it would be like a paradox of the peace process. So in this very complicated political context, the judge needed to resolve what would be the best way to protect the Amazon. And that's why the the Supreme Court declared the Amazon as subject of rights. So this has lots of effects. You can say it has some symbolic effects. New generations talking about what's happening in a part of the country that wasn't part of our mind because of the war. But you can also say that if you take this seriously, maybe you wouldn't allow many of the activities you are giving permits to be done there. So maybe some mining projects, some oil extraction projects, the use of chemicals to kill some crops wouldn't be allowed there. It's been 2 years since this case was decided, and there's the question, what's happening with that? So implementation is a challenge because you cannot pretend to change decades of harm that has been allowed by our current laws with this new concept. So we need new tools to allow people to live from preserving and maintaining their ecosystems and not cutting down the trees. And that's what we have been doing for the past year. We have been doing workshops in the Amazon with indigenous communities to know what they want for the future of the Amazon. What is their idea of development that is maybe not the same idea that the government or our current laws have had. So that's basically the case I wanted to share with you, and I'll be happy to answer questions at the end. Thank you.
Well, I would like to begin by acknowledging you in the first language of my country, Rorangatirama, tēnei taku mihi atu kia koutou, tēnā koutou, tēnā koutou, tēnā koutou katoa. And that means to the distinguished people gathered here today, I acknowledge you, I acknowledge you, I acknowledge you. Can I also begin by acknowledging the University of San Francisco? It's tremendous to be here. I first started visiting San Francisco in 1986, and I did a tally yesterday, and to the best of my knowledge, I think I've been here about 35 times since. It's my favorite city to walk all over those hills, as I did today. One never likes to gloat, but I've walked 22 kilometers today to Sausalito, and I caught the ferry back. It really is nice to be here among you to talk about something that occupied my life for about 9 years. There is a lot I could talk about, but I best better give you some background. For 9 years, I was Attorney General. I don't think there are many Attorneys General of the United States who hang around for 9 years. It looks as though the current one will be gone by tomorrow. And I was also the Minister for Treaty of Waitangi negotiations. So what does that portfolio mean? The Maori, no one knows when they came to New Zealand, probably about 1,000 years ago, and they came out of East Polynesia. If you go to Tahiti, the Tahitian language and the Maori language is pretty much the same. And they were there for many years, and then American whalers started to arrive, the French arrived, and then the British arrived. And in 1840, a treaty was signed at a beautiful place in the far north of the North Island called Waitangi. And the Treaty of Waitangi acknowledged the sovereignty of Queen Victoria over New Zealand. It gave to Maori all the rights and privileges of British citizens, and the Crown, or the government, promised that it would protect the treasures, or taonga, of the Maori thereafter. New Zealanders, in many respects, like to say that the project has been highly successful, but the reality of the matter is that the Indigenous people of New Zealand were done over. just like other Indigenous peoples. Perhaps it was more subtle, not like the Australians, who are not noted for their subtlety, the way they treated the Aboriginal people, for example. But what we had was a litany of broken promises. And we had land that was simply taken, or raupatu. We had shonky land deals, and basically for all that Maori contributed to that project called New Zealand, essentially it's not hyperbolic to say they were betrayed, they were let down. But they're a bolshy lot, and in the 1960s there was something of a revival, and they began to say, the younger folks started to say to themselves, well, why should we put up with this nonsense? And the government of the day recognised that something needed to be done, so established a tribunal, the Waitangi Tribunal, whose task it was first to investigate contemporary grievances, and then in 1984 its jurisdiction was expanded so that it could investigate historic grievances going back to the time the treaty was signed. And then a whole lot of reports were prepared, and they were piling up, and as the Prime Minister of the day told me in the early 1990s, they could either be used as doorstops or they could be acted on. And so an office was created called the Minister for Treaty of Waitangi Negotiations, and settlements got underway. There are about 80 or 90 tribes, or iwi, in New Zealand, and many of them have now concluded settlements with the Crown, which basically consist of an outline of the facts. There's nothing like getting the facts right and the Crown acknowledging where it went wrong, a formal apology, and that in itself could be the subject of a lecture, commercial redress, not just money, but the right of first refusal to purchase surplus state property, and cultural arrangements, the return of precious land. Normally the test was small and discreet, but normally it's a lot more than that these days. Burial sites, precious pieces of land that are of great significance to the settling tribe, and also co-governance arrangements. Whenever I go on to a marae or a gathering place of Maori, they will always acknowledge me by reference to their river or to their mountain or to their lake. And so having seen rivers and lakes basically destroyed because of very bad stewardship, they wanted some say in their revival. And so we started to enter into what were called co-governance arrangements, where you would have equal numbers of the settling tribe and the local authority getting together to work out how to fix up a river or fix up a lake. And generally those arrangements worked well. But I needed to tell you all that because I come to the first seminal decision, which deals with the concept of the rights of nature, and that involves a very proud and remote tribe of New Zealand called the Tūhoe, who were in history treated very, very badly. They lived in and around a park, or an area which became a national park, should never have become a national park, called the Uraweras, larger than Luxembourg. And they had lived in these hills for years and were very hospitable, but very independent. And throughout the course of the 20th century, successive governments basically pushed them to the sidelines, and then in 1954 their area, the Uraweras, became the Te Urewera National Park. And in New Zealand, national parks have a very, very great significance because people say, well, it is my right to wander at will, it is my right to hunt, and the Maoris aren't going to stop me doing it. And this is a very special national park because unlike many national parks, it's full of Maori land, private Maori land. And so there were issues arising about how we were going to deal with this particular settlement. They didn't want a co-governance arrangement, didn't cut the mustard so far as they were concerned. And I was in a position where I had just persuaded my cabinet, or almost persuaded my cabinet, that we should just transfer the land back to them. But because of the significance of the concept of a national park, that was thought to be a bridge too far. And so the issue became, well, how are we going to get the settlement, because these guys are very principled and they're not going to accept co-governance, so we can't transfer it back because what I call the NRA, the sour right lot in New Zealand, would go ballistic. So we had to work out what we were going to do. And I was very fortunate to have a chief Crown negotiator in a fellow called John Wood, who's just recently retired as Chancellor of the University of Canterbury. He was a very distinguished diplomat. Twice he was our ambassador to the United States and was also ambassador to Iran. And he and a group of clever thinkers got together and they found the seminal text, Salmond on Jurisprudence. Sir John Salmond had been a professor of law at Victoria University, where I was educated, and then he became Solicitor General and then a judge, a very distinguished man. Some of you may have come across Salmond on Jurisprudence or Salmond on Torts, and this is what he said in Salmond on Jurisprudence. Legal persons, being the arbitrary creations of the law, may be seen as many kinds as the law pleases. Those which are actually recognised by our own system, however, are of comparatively few types. If, however, we take account of other systems than our own, we find that the conception of legal personality is not so limited in its application, and that there are several distinct varieties. So we started to think about how would we perhaps build on this concept of legal personality. Of course, that very quickly led to Professor Stone and the work that he did in the University of California, and his seminal article on whether trees should have legal standing. But we also looked at our own system. We found that in 1987, a High Court decision had recognised that a natural resource, in this case the waters draining into the Waikato River, could be represented by a guardian before the court. We also found a 1925 Privy Council appeal where it was held that a Hindu idol could be represented by a friend appointed by the court. For those of you who don't know what the Privy Council is, it used to be the top court for India, Australia, Canada, New Zealand, many African colonies, and everyone has basically set up their own Supreme Court. Now, Canada did it in about 1948. We did it in 2003. It was great going to the Privy Council because you'd fly 10,000 miles, sometimes for an hour-long hearing. It was great for fees. And so that was the Privy Council, but that goes back to 1925. And in 1991, the English Court of Appeal was prepared to grant standing to an Indian temple as a party competent to be represented before the court. And also in my own university, a professor who taught me first-year law, Professor Angelo, had written an article in 1996 where he said the common law would have much greater flexibility for dealing with taonga or treasures if some treasures had legal personality, because this characteristic gives the subject rights and duties under the common law. And so we thought, well, if this is the way that a lot of people have been thinking for many years, why don't we think about giving legal personality to what was then known as the Te Urewera National Park? And that's exactly what we did. And on that basis, the tribe was prepared to settle because they recognised giving an independent identity to the Ureweras was something that accorded with their own worldview of things. And so that is how that settlement took place. The stumbling block was always going to be, well, through this legal personality, if there is a body which will govern it, was it going to be 50-50? And the Tūhoe people didn't want that. They wanted a majority of Tūhoe running the show, we agreed on an interim arrangement, 50-50 for 3 years, and then the final decision was going to be made as to a Tūhoe majority, and the Cabinet accepted that. And on that basis, we could reach a settlement with that tribe, and it's been a Tūhoe majority now for a couple of years. The world hasn't ended. They are dealing with pests in a slightly different way from other parts of the country. For example, they don't like what is known as 1080. Do people know 1080 is a particular poison which a lot of people don't like because they say it kills indigenous birds as well as possums, rats and weasels and so on. They have a different way of looking at things, but they have prepared a management plan for the park, and fingers crossed, it's underway. It's going to take a long time to fix it up, but we'll see what happens. And then we came to the Wanganui River, and the Wanganui River is a beautiful river which runs from the central North Island to the sea. It's New Zealand's third longest river, and I can do no more than quote briefly from the Waitangi Tribunal about its history. For nearly 1,000 years, the various hapu or sub-tribes have held the Wanganui River. They were known as the river people, for uniquely among the rivers of New Zealand, the river winds through a precipitous terrain that confined most of the large population. And there were, last century, some 140 river settlements, and these people lived along the river for many, many years. And when Europeans arrived, it's fair to say that rarely I've never come across such a litigious bunch as the Wanganui River iwi. They went to the Waitangi Tribunal, they went through all the courts of New Zealand, they even went to the Privy Council, they went through the Maori land court system in an endeavour to say that, hold on, you cannot take this river away from us, it's so much part of us. And Dana had, there it is there, that wonderful saying, e rere ko mai te awa nui, me ai te kahui monga ki Tangaroa, ke o te awa, ko te awa ko o. The great river flows from the mountains to the seas. I am the river, and the river is me. It was inextricably linked with their personality, with their view of the world. When I was first told that, I am the river and the river is me, I wondered what they were smoking. And because I was looking at it through Anglo-Saxon terms. But once you start to drill down and get an idea of the vision of these people and the links with these people that go back almost 1,000 years to this river, one sees that they are utterly inextricably linked. And once again, we drew on this idea of legal personality to solve the particular problem and get the settlement. Because it's fair to say that I don't know what the position in the United States is, or I had some discussions last year at the University of New Mexico, but English common law always says no one owns water. Although I have to tell you, watch the space in New Zealand, because I think there are going to be some very interesting issues about that, and I'm acting for a large iwi or tribe that has a completely different view of things now. But no one owns water was it has been the mantra that's been recited for many years. And so we couldn't transfer the river to the iwi, but the idea of the river owning itself was the way in which we dealt with those particular issues. And then we appointed, under the legislation, 2 persons to represent the river so that it would have standing in resource consent applications or applications before the courts of New Zealand. And those 2 representatives, there's one Crown representative and one appointed by the iwi. And so their organisation is now set up. They've been put in funds so that they can address the issues confronting the iwi, and I've been told to wrap up, so I will stop there. It's a fascinating story. At the risk of finishing with an advertisement. It's the subject of a book that is in draft form, and I hope that if I haven't gone on too long, shall be invited back at some stage later this year to tell you all about my book.
Hi, it's so nice to be here. My name is Mari Margill with the Center for Democratic and Environmental Rights. This is a really incredible panel. It's so nice to join these folks. And I think the story that Christopher just told us, I think is really important, not only for what they accomplished in New Zealand, but the idea that it's so difficult to make change. The Maori have been working for decades and generations to make a fundamental shift in their relationship with the river, with other ecosystems. And it reminds us that change doesn't just happen. It never just happens. It only happens when people join together to demand change, to force change. And this story that he told us, I think, is just so brilliant in terms of what they were able to do when they joined together and forced that change to happen. My organization and my work within the Rights of Nature movement has taken me to different places in the world, from the first communities in the United States to establish the rights of nature into law, to Ecuador in 2008, where we were invited when they were drafting a new constitution. We met with members of their constituent assembly to talk about what is the rights of nature, what they would call Pachamama. And that year, Ecuador became the first country in the world to enshrine the rights of nature into a national constitution. That was now just over 10 years ago, and once Ecuador did that, they were sort of the first to go into the breach. And once they did, it kind of opened the eyes of people around the world, and we started getting phone calls from people in India and Nepal and other places saying, this is really interesting, can we learn about this? We want to understand what it would mean to do this where we live too. And so I wanted to take a step back from the two stories that Gabriela and Christopher and Geneva is going to tell us as well, to talk about how we got to this moment and why there's a growing movement to recognize rights of nature, rights of the natural world. And so we've worked across jurisdictions, from the most local to the most national. We've worked across cultures, we've worked across language, we've worked with indigenous peoples, with non-indigenous peoples. And what I have seen over the past decade or so is a growing recognition that something fundamentally different needs to happen. And that fundamental difference that needs to happen comes as people are seeing these overlapping environmental crises. Of course, we know that ecosystems such as coral reefs are collapsing. We know that species extinction rates are far beyond natural background rates. And of course, climate change. And every day it seems like there are headlines telling us how these overlapping environmental crises that have happened as a result of human activity, that they are only getting worse and that they're accelerating, and that something really fundamental needs to change. And so we have seen people from all parts of the world saying, you know, enough is enough. We need to make a fundamental shift, and we can't wait, for example, for the UN to do it. We can't wait for our national government perhaps to do it. We just have to do it wherever it is that we are. And that common sense of urgency and concern also comes with very strong parallels in law and governance. So whether you're in Ecuador, the United States, and Australia, another place that we work, we see very parallel structures of law. And what I mean by that is we see, for example, environmental laws all over the world work very, very similarly. Those environmental laws, like our Clean Air Act and our Clean Water Act here in the United States, and similar laws around the world, those laws all treat nature as without legal rights. Nature is treated as property, it's treated as an object, it's treated as rightless. And environmental laws, what they actually do is regulate human use of nature. So we see laws that do things like legalize fracking. And what does that mean in terms of how do we use nature? It means that we get to use millions of gallons of fresh water at every frack well that gets contaminated through the fracking process. We get to drill through the earth for miles, through aquifers, through the ground, and cause explosions underground to release gas. And not only is that destroying the soils, but it's also then releasing gas, which is polluting our air and contributing to climate change. So there's so many ways that fracking as one example, but of course we have mining and we have drilling and we have laws that allow companies like Nestle and other water-wielding companies to put, giant straws through our aquifers and take millions of gallons of water every day from an aquifer, for example. So we're using the natural world and we're legalizing and authorizing that use under environmental laws that are really very similar around the world. The consequence, of course, of that are these overlapping environmental crises with the ecosystem collapse and species and climate change. And so we've seen people all over the world saying, we can't continue to do this. We are treating ourselves as, Gabriela spoke about the Constitutional Court in Colombia, which is the first to recognize the rights of an ecosystem in that country in 2016. In that court decision, the Constitutional Court of Colombia said, humankind needs to stop considering itself a quote-unquote ruler of nature. We need to recognize that we are part of nature, and that part of that fundamental shift is changing literally how we treat nature under the law, from being rightless to being rights-bearing. And of course, there are parallels through past movements. So here in the United States, of course, we have a long history of movements. We have the abolitionist movement, which transformed enslaved people, slaves, from being considered property of others to being rights-bearing people. The women's movement transformed women from being treated as property of their husband, of their father, of their brother, to being rights-bearing. Indigenous peoples went from being considered to be without rights to being rights-bearing. None of that happened just because they happened. That happened because people joined together and demanded and forced the kind of change that Christopher was talking about in New Zealand. It required fundamental shifts in both how we think about something, so a cultural shift, and also then a parallel legal shift to transform literally how people were treated under governing systems. And that's where we are today with nature. Nature is sitting over here in this property construct. And the rights of nature laws that we're seeing from the local to the national level in different countries is about transforming how nature is treated under the law from property or an object to being rights-bearing, from rightless to rights-bearing, and those rights include things like the right to exist, the right to thrive, the right to flourish. And Ecuador's constitution includes the right to regenerate, that idea that an ecosystem can have a level of resilience, that it's able to heal thyself. In Ecuador, they asked, well, what about, can nature have a right to evolve? And we said, of course, it must have a right to evolve. That's about nature being able to perform its natural function, its natural capacity of a river to be a river, a forest to be a forest. That involves evolving. So in Ecuador's constitution, nature possesses the right to evolve. And Gabriela also mentioned the right to be restored. We don't have the right to be restored under conventional environmental laws. At best, you see corporations negotiating with governments to calculate how much of a fine they're going to pay for having gone above what pollution limits they're already given. And those have nothing to do with what it's going to cost to bring a river back to whole, back to a clean, unpolluted, healthy state. And so this right to be restored means in these rights of nature laws that damages, so monetary damages that the polluter or the harmer of nature has to be calculated an amount that's going to be able to bring that river back to a whole healthy state. And so we see this growing movement around the world to secure, to enshrine, to protect legal rights of the natural world. And those rights can include things as well as a right to a healthy environment, the right to healthy biodiversity, the right to clean air and clean water, and including the right to a healthy climate for nature. And this recognition of rights, I think, is really critical for us to understand. It's not just another tool in the environmental toolbox that environmental activists can pull out when they need something new. It's really about a fundamental shift in how we govern ourselves toward the natural world, which more and more people are saying is an absolutely necessity. And that means not only being able to go into court, like in Ecuador, there have been many cases that have gone into both provincial courts all the way up to the Constitutional Court, in which people are going into court to represent nature in the name of and on behalf of nature to enforce and defend nature's rights. And so that people don't have to prove that they have standing to go into court. And Gabriela spoke so nicely about how difficult it is to prove that you even have the ability to appear before a judge. In Ecuador, where you have constitutional rights of nature, it's nature that has the right to go into court to defend and enforce its own rights. And people are stepping into the shoes of a river, for example, to be able to do that. And we've got to go, though, beyond just being able to go into enforcement and defense, so getting out of the courtroom to going into implementation. And what does that look like? So it's been over a decade now in Ecuador, and mainly what we have seen are court cases because the national government has yet to really operationalize what does it mean to implement that nature possesses constitutional legal rights. Courts have affirmed that those rights exist and have, through court decisions, instructed certain things to happen to correct for when nature's rights are being violated. But what does it mean to actually implement? That is, what does it mean when we as human beings begin to make decisions that are not just in our interest, but are also in nature's interests? That we move from an anthro to an ecocentric perspective of the world. And what that means is, for example, for those of you who are familiar with, for example, let's use fracking, because we have so much of it here across this country, that when a company, an oil and gas company wants to frack in a community, they have to go to the state to get a permit. So they apply to the state government to get a permit to be able to come into your community to frack. And they have to do things sometimes called like an environmental impact assessment to evaluate what different ways can they do this that will be the least harmful. But of course, these environmental laws are set up to make sure that fracking happens, not to protect us from fracking. And so when we think about rights of nature, and if we think about how are we making environmental decisions, and perhaps with an environmental impact assessment, for example, we have to recognize that the highest legal protections that we have in human law are legal rights. And so that means that all of our activity as human beings, as governments, have to make sure that they don't bump into and interfere with those legal rights. Just like today, all of us here as Americans possess, and I'm sorry for the non-Americans, but we have a First Amendment right to free speech. And I hope you do too in your country, I know you do. But the point is that government can't interfere with our First Amendment right to free speech. So government has to work around and make sure that its actions are consistent with our constitutional rights. And that's what it means for nature too. So human activity can't interfere with those constitutional rights that nature possesses, because that's the highest form of legal protection that exists. And so we, as human beings and as governments, have to determine how do we make environmental decisions that don't impact the right of an ecosystem to even exist, the right of an ecosystem to regenerate, to be restored. That means making a really fundamental shift in the kind of governing decisions that we're making. And that's where we are today in places like Ecuador. They're the longest having a national law in place. And we're now working with the National Assembly to help them to think about what does that implementing legislation look like so that they're beginning to actually make real the promise of their constitutional rights that they have recognized for nature. There are other places that are doing this, of course, and you're hearing from some of the panelists on this tonight. But just in the past 6 months, we've worked with places like the Philippines, where a national rights of nature legislation was introduced into the Senate there. In Sweden, we've been working with members of parliament to introduce a constitutional right to amend their instrument of government, the Swedish constitution, to enshrine the rights of nature within the Swedish constitution. Just a few weeks ago, the Menominee tribe of Wisconsin adopted a resolution to recognize rights of the Menominee River, where their people originate from and which they believe is a source of their lives and all life. And it's taking shape in different places all over the world, from the most local to the most national and even in the international sphere as well. And so I think it's very, very important for us to think about why people are moving in this direction. What does it mean when movements build? How do we make the kind of transformational change that we believe is absolutely essential if we have any chance of achieving true sustainability, true environmental protection, not only in our own communities, but really around the world? And that means that we have to transform how we live on the planet. And it's not going to be enough for us to try to recycle and compost and drive hybrid cars, all of these things that I do and do happily and willingly, but no, it's not enough to affect the larger systemic change that's truly needed. And that, to us, when we look at past movements that looked at legal systems that enslaved people, that oppressed women, that oppressed indigenous peoples and others, that they saw legal systems that had to go through a fundamental shift and how they treated vast populations of the people that they served. And that's where we see nature today, that we need to make really fundamental shifts in law and governance, the very purpose of law and governance itself, to be about protecting nature, the thing that we depend upon, that we treat as a luxury. But we have to make a fundamental shift in terms of how we govern ourselves toward nature, or we're not going to survive, and of course we're killing everything else around us. And so I would just leave you with that I think we're at a really inspiring moment despite all of the headlines, and that we see more and more places doing this very, very difficult thing because they believe it's necessary. And as activists, are always told, well, if they're yelling back and throwing things at you, then surely you must be doing something right. And we're seeing that play out in places like Florida, where the chairman of my board was at the University of Florida Law School in Gainesville over the weekend. And they were having an environmental law conference, and they dedicated a full day to the rights of nature and heard from different activists across Florida. Gabriella was there as well to talk about what is this rights of nature stuff, what can it look like if we're going to recognize rights of rivers and springs here in the state of Florida. And as these laws have beginning to be proposed just in the last 9 months, this stuff has started to happen, and we've been working there with a number of communities and counties. The state legislature has decided that it doesn't even want any of these laws to be voted on. It doesn't want to see anything possibly going into place. And so the state legislature has now considering and is likely to pass a preemption bill, which will prevent local communities across the state of Florida from passing rights of nature laws. And the reason they're doing that, of course, is that they see that this is a really kind of fundamental change, that people are beginning to think differently, and they're trying to change the law at the local level to make this kind of change and then drive it upward to the state and even constitutional federal level. And it's been really interesting because the legislators have said, we can't allow that to happen. And so what they want to do is strip any authority from people on the ground to be able to make this kind of change. Essentially what they're saying is, we're preventing people in our communities, the people that we represent, from being able to protect the environment. We're not going to allow them to do that. So that's the kind of pushback that we look for to say, hey, we're actually doing something really fundamental and different here, such that the people are beginning to throw stones. And that's, a marker of success. So I'll leave you with that. Thank you.
All right, OCO. My name is Geneva Thompson, and I first wanted to thank Dana and Ariella and the University of San Francisco for having me today. I would also like to thank the panelists for sharing your stories and insight. I have learned a lot just this evening, but also have learned a ton researching all of your efforts when I was drafting the Yurok tribe's rights to the Klamath River. So I want to say thank you for all of your work. Because myself and the Yurok tribe has benefited so much from your advocacy. As introduced, I am the Associate General Counsel for the Yurok tribe. I'm also a citizen of the Cherokee Nation, and it's quite an honor for me to be here to represent the Yurok people and represent the efforts that the Yurok people are doing to protect not only their ancestral homelands, but to protect the environment and the species that rely on that environment. So it's a great job, and I'm really enjoying working with everyone and on these efforts. So first off, I wanted to put a quick disclaimer up because we are actually still in the legislative process of developing the rights to the Klamath River. What passed in May is what I've been calling, it's kind of like an executive order. And in that executive order, it has told my office to write the law. And so we are still drafting that law. And so everything that's up here is for conversational purposes. And please don't think that that's set yet, because the people haven't reviewed the final product, the tribal council hasn't voted on it, and it's not codified yet. So I just would like to put that disclaimer out there. So if you see things that change in the future, that's why. First, I really thought it would be important to open up this conversation with the Yurok worldview on protecting Yurok natural resources. So as you can see up here, here's a small quote from the Yurok constitutional preamble that really solidifies the government of the Yurok people and its duty to protect natural cultural resources. You can see here that it's the rivers, the trees, and the animals, and it's all part of the imbalance, and it's part of the Yurok people and who they are. And the reason why I bring this up is because when council first directed us to write this Rights of Klamath River law, people are like, we already treat the river that it has rights. This isn't a new idea. Why are we writing this down? Why are we doing this? Because this is how we already practice. And how it was explained to me and why we are moving in these steps is we're actually just codifying Yurok lifeways and Yurok understanding of how to interact with the river. And by codifying that understanding, the Yurok government can then enforce that those laws and understandings on non-Yurok members who are in the reservation harming the Klamath River or other Yurok natural resources. Weeroy is river in Yurok, and since time immemorial, the Yurok people and its members have been in a strong relationship with the river, and this is just a current practice that will always go over in the future. Part of that is the importance of the salmon and the Klamath River, and Miss Matson here, she is a well-respected Yurok elder, and I wanted to put her words up here, and if you would like to see her interview, I put the link right there. We're all gonna die right here, talking about the Klamath Salmon Wars. And so this is a great video where you can see a lot of the Yurok elders who were on the river defending the salmon and the river when the federal government and the state of California was trying to tell the Yurok people they are not allowed to be on their river, they're not allowed to fish in their river, and they're not allowed to practice their cultural lifeways. And so if you're looking for more information about the Yurok people and the importance of the river, I would definitely suggest that you all go check that out. So as I kind of discussed already, the Rights of the Klamath River Resolution 19-40 was adopted by the Yurok Tribal Council on May 9th, 2019. And this is seen as kind of like the executive order from council saying this is where we want to go, figure it out, develop the laws. The resolution itself established the rights of the Klamath River, but it did not provide like all the detailed mechanics of the law. And that's what we're working on through our legislative process. But what we are figuring out right now is we have the definition of Weeroy and the Klamath River. And through this, we are trying our best to develop a law that not only is symbolic and captures the importance and the rights of protecting the Klamath River, but that it's also future-looking and where the tribe wants to be and what jurisdiction and authority the tribe would like to exert on persons or entities or corporations that are harming the river. But we also really wanted this law to be based in today's reality. And as I'm sure some of you, or all of you know, the United States government has not been great to Native people, and through very serious actions of, military force, wars, Congress, the Supreme Court, the president, through many, many different actions, the rights of indigenous people have been diminished, and the rights of indigenous governments have been diminished over jurisdiction in their ancestral homelands. And so for some background for the Yurok tribe, the Yurok tribe's ancestral territory is a huge swath of land, and they are now, the federal government has only recognized 1 mile on either side of the Klamath River, up 45 miles from the shore. And so you can see the yellow strip right there is just the the Yurok reservation. But the ancestral homeland, it goes up almost to the California-Oregon border and all the way down to, I don't know if anyone's familiar with Northern California, but Trinidad area. And so the ancestral homeland is much bigger than the reservation. And so when we were thinking about this law, clearly the Yurok people would like to have their whole ancestral homelands back and would like to assert jurisdiction over the whole ancestral homelands. But right now, where we're based in reality, it's going to be harder to bring claims outside of the reservation. And so that's the trick that we're trying to do right now when we're drafting this legislation, is the symbolic, the future-looking, but also based in today's reality. I threw up this map right here so you could see where the whole Klamath River Basin is. And so we would like, from up the headwaters up in Oregon all the way down to the Pacific Ocean, the idea is to protect this whole river basin from any harms impacting the river, because those harms themselves not only hurt the river themselves, but also hurt the Yurok people and the species that the Yurok people rely on. To further define this, the idea of WEROI, we've created this definition of a cultural riverscape. And so it's similar to a cultural landscape, where a cultural riverscape is a river and its viros, including cultural and natural resources and the wildlife or domestic species therein, associated with historic events, activities, or persons, or exhibiting other cultural and aesthetic values. Cultural riverscapes are associated with the significant patterns of events in traditional histories and groups of people who built their cultural lives around the river, its fish, plants, wildlife, and water. So through this definition, the plan is to assert that under any National Historic Preservation Act claims. And so kind of similar to what we were discussing with the environmental review process, if there's a major federal action that's going to impact the environment, the federal agency, the lead agency, must consult with any federally recognized tribe. And that authority is under the National Historic Preservation Act. And so by defining a cultural riverscape and putting that in our laws, we can then use that to influence federal and state actions of any future project that's going to impact the Klamath River. And so the idea behind that is, again, going back to the whole Klamath Basin, if we can't assert Yurok law, we can use Yurok definitions of what a cultural riverscape is to influence federal and state laws. I don't know if folks are familiar to the California equivalent of NEPA, but we can use the same definition under the AB 52 consultation rights to ensure that Yurok understanding of how important the Klamath River is consulted on and implemented in any environmental review process. The purpose of the law is, one, to exert inherent sovereignty of the Yurok tribe to protect the health and welfare, well-being of the Klamath River. And then here we have the rights that we're working on establishing for the Klamath River, to exist, flourish, naturally evolve, and to have a clean, healthy environment. And also we have here to have a stable climate, free from human-caused climate change impacts. The goal in putting that in there is the Yurok Tribal Council has identified the fact that we are having a difficult time protecting the Klamath River from unknown causes and harms associated with climate change. And the idea behind the Rights of the Klamath River legislation is to allow a flexible law that would allow the Yurok tribe to see harms that might not be associated with a specific corporation. It might be more specific to the harms associated with climate change, and try to address that through our legal system. One example that we're dealing with right now is during the commercial fishing season, the salmon never returned home. And all of the reports said that the salmon were going to be here. It was going to be a great fishing season. All of the Yurok people geared up, bought new nets, got their boats ready, went out on the river, and there were no fish. And the scientists, both at the Yurok tribe and in the federal and state equivalents, didn't know why. And so they actually had to go out and figure out why. And the current theory I have heard right now is there's actually was a warm water current that was blocking the access to the Klamath River from the ocean. And the salmon couldn't find the opening, and we're just trapped behind this warm water and just were never able to make it up the river to spawn. And so that's something that, what corporation do you pin that to? You know, like who did that? And so we are grappling right now with how we can define this law and write this law in a way that would allow us to be flexible and address climate change issues. This is more of the rights of the Klamath River. We here have the two sets of rights. First is establishing the new rights of the river, as we already discussed. And then the second is just establishing the Klamath River has standing in legal proceedings to adjudicate its claims. And so here, while the river itself can't walk into the courtroom and argue its claims, this law is set up in a way that Yurok people and also the Yurok tribe itself can represent the river in claims before the Yurok Tribal Court. This law is also being developed to codify the rights of the Yurok people as it relates to the Klamath River. Here we have, again, the right to intervene, the right to represent the river, and also the right for direct, indirect, and indirect action. This definitely relates back to the salmon wars that we discussed before when with Ms. Matheson and a lot of the Yurok elders were out on the river defending their rights. This was something that was really important, and every time I talk about this law, everyone asks me, it's like, okay, but we have the right to protest still, right? It's like, yes, of course, we're going to put that in there, we're going to be there, because the Yurok people have since contact been fighting to protect the Klamath River. Another example of this fight is the dam removal project that's happening in the upper parts of the Klamath River. There's 4 dams that are currently going through the process of being decommissioned and brought down, and it's the Yurok people who led that movement, who were making the calls, talking to the legislatures, making it happen. And so that's something that is super essential for the Yurok people to have in this law. This is the right for the Yurok people to have the right to practice their cultural ways of life in relationship with the river. We thought it was important to codify this, not because we don't know what these rights are, but as a way of putting up a defense to anyone who wants to claim that if a Yurok person goes out and fishes and takes a salmon, that somehow that person has harmed the river. So this is more of making it very clear for what actions constitute a harm and what actions don't constitute a harm. Because we felt if we left it vague, we'd be in court defending people's cultural rights all the time. And that's not the purpose of this law. The purpose is not to stop the Yurok people from fishing. The purpose is to ensure that the health of the river has the right to be healthy, and that the fish can be back for the Yurok people. The rights of the Yurok tribe as the government entities, not only to enforce the provisions of the law and intervene in any rights, but also that the Yurok tribe is the government entity that dictates what happens within the Yurok jurisdiction and sets the laws. And so we wanted to make that very clear. And then lastly, the Yurok Tribal Court jurisdiction. And so this is, again, going back to the conversation where we're trying to draft this legislation that fits in today's reality. For anyone who is a student of federal Indian law knows the Montana exceptions well, but essentially the Supreme Court has determined that that any federal Indian nation does not have the right to doesn't have jurisdiction over non-members within the reservation unless it meets 2 Montana exceptions. And so these 2 exceptions are the contractual exception, and then also the threaten and have direct effect on the political integrity, economic security, subsistence, and health and welfare of the Yurok tribe. And so because we know this is our reality, We are working to draft legislation that ensures that it's extremely clear that harming the Klamath River does have a direct effect on the political integrity, economic security, subsistence, and health and welfare of the Yurok tribe. And then to meet the first exception, this contract exception, we are updating all of our permits. We are updating all of our other environmental laws to make it very clear if you're going to do work on the Yurok reservation, you are essentially signing a contract with the Yurok tribe, and therefore agreeing to Yurok court jurisdiction. And then through that step, the Yurok tribe can then enforce the rights of the Klamath River law. And so we're trying to find as many creative solutions as possible to navigate our current reality with hopes that jurisdiction will be more easier to establish in the future. So that's the move we're trying to make there. And then again, we're asserting any persons who enter the Yurok reservation will fall within one of those two Montana exceptions. And so with that, I will conclude my presentation. Wolkal, Wado, and thank you. And I'm excited to hear y'all's questions.
All right, well, thank you so much to all of our panelists. And as you can see, there is a lot going on this issue around the world, and different approaches are being utilized to address lots of different issues. It's not just about the environment. It's not just about human rights. It's not that any of these efforts are trying to take away people's right to protest or people's right to develop, right? That is still part of it, but it's about finding a new way to do that where we don't harm a certain segment of our planet that has an equal right to flourish as we do as human beings. And particularly in the United States and some of the other let me just say, countries that have followed, Locke's ideas about the right to property, those kinds of ways of thinking about nature have not been, part of the conversation for a long time. And, I think everybody on the panel has shown that, there's so many different ways to engage now and to come up with creative solutions to the problems we're facing. And I know, among the students in the room, there are a lot of you that are thinking about potential careers as future lawyers, and there's, always that question of, do I do that? And, I think we've seen in the United States just in the last couple of years that lawyers in courts have the ability to be a bulwark against negative action and also a force for positive change, but it's not just about that, right? It's cultural shifts, it's normative shifts, it's structural and legal shifts, and we have to find a way to have the conversations that bring it all together to make these kinds of changes. And so I thank all of you very much, and we do have some time. So I would like to open it up for questions from the audience. We have 2 microphones here. Actually, we are recording this, so just be aware if you ask a question, it will be recorded, and we do need you to ask the question into the microphone for purposes of the recording. So does anybody have any questions they would like to start off with?
Great. First off, I just want to say thank you to all of you. Can we give them a round of applause? This is really inspiring stuff. And I think we live in a really interesting time. And I just want to hear where you all find hope. As you've mentioned, the extinction crisis, climate change, glaciers receding, like this is a really interesting time, and potentially these stories are part of that, but I would love to hear you all's perspective on that.
Go ahead. I'll go first. Is this on? I think it's on. I think you were probably sitting behind me in the restaurant this morning when I was having coffee with someone, and I asked her the exact same question. Where does she find hope? And ultimately, our conversation focused on the fact that we find hope when we see people doing things, even in the face of how bad it is out there. Honestly, whether you're working on environmental issues or social justice or whatever it might be, it's not a good time. And I draw so much hope with the people that we partner with, in different parts of the world and just in general in my day-to-day life, for people who are doing stuff even when it looks hopeless. And that's always when change happens, is when people are willing to do stuff even in the face of everything telling them they can't, or it's not going to work, or it's going to take too long, and the problem is so urgent we have to do it now. If we just don't start doing it, nothing's going to happen. We can't wait around to hope that the powers that be do the right thing. They don't generally lead. The people lead, and our institutions and governments follow. And for me, that's where I draw hope, is when I see people doing stuff that is so difficult to do, but they see as necessary.
Anybody else want to jump in on that one?
Yeah, I think it's one of the great questions of the modern world. My favourite theologian or spiritual director is the former chief rabbi of the Commonwealth, Jonathan Sacks, who has actually written a book on Exodus, which he calls the meta-narrative of hope. And if ever there is a virtue that needs to be extolled in these times, it's the virtue of hope. And I think that the way you do it, and it's great that we're in a sort of a Jesuit law school, is that you've got to sort of use the skills of the Jesuits, master the arguments of your opponents, and outsmart them, which is historically what the team of St. Ignatius Loyola did. So it really is mastering the arguments of your opponents and working steadily and without interruption toward a particular goal. Look, I don't come from a left-wing point of view. The political party I belong to was a centre-right political party where liberals and conservatives, the sort of people that we would support would be the current governor of Massachusetts, Charlie Baker. And so even in a centre-right administration, I got some of this stuff through. And it's not a question of being defeatist. If you miss out on a particular path, as I did with the first tranche of the Tūhoe settlement, you've just got to keep on coming back till you achieve your end.
Oh, that's a difficult question. I think I find hope in meeting other communities around the world that have the same struggle we have in the global south. So as Mari mentioned, last week I went to Florida and learned about how the wetlands are polluted there and how you have the case in Lake Erie. And then you go to Sweden and you found they have also a lake that is under threat because of pollution. And you have common people like us thinking about this every day. We were a bunch of kids who filed a lawsuit against the government. Nothing was on our side, and we achieved a change. So there's lots of people thinking that a world could be better and are dedicating their studies and their time to share that message with others. So I feel like hope is inside each of us, each of you who are here in a Thursday night hearing about rights of nature in other places. I think there's hope in common people doing common things and spending their time in those matters.
I think I'll just quickly add, yes, that's a very hard question, but I think I find my hope in seeing the resiliency of indigenous people and communities and nations, because just knowing my own people's history and learning so much about the Yurok people, it's been a tough go for a long time, and indigenous people are still here, still pushing, and finding creative solutions in difficult situations. And it has been I mean, not only am I, as an Indigenous person, I feel that, but being an attorney for an Indigenous nation who is working really hard to find very creative solutions to better their people, it's that energy and that push keeps me going, keeps me working hard, and keeps me, I guess, staying on my toes and trying to help them reach their goals. And so I think that's where my hope comes from.
All right, I want to follow up on that hope question to ask all of you, well, first of all, thank you for all your efforts, but you are using the power of the law to make this change, to change institutions, to guide what humans should or should not be doing. What can all the rest of us do to support those efforts? Like you often hear demonstration, litigation, legislation, right? Education, communication, celebration. So is there anything you can share with us or challenge us to do to support those efforts?
In our case, interdisciplinarity was key. So we were a group of not only lawyers, but we had economists, we had engineers, we had a journalist, we had very deep conversations with philosophers to understand how to make what Mari just mentioned, a shift. So I feel like interdisciplinarity and being aware that all the professions had to do with the earth we inhabit, and all our actions have consequences. So just the fact of being aware of that is a huge change.
Never underestimate the power of protest, which may sound strange coming from someone with my background, but so much has been achieved in this country through people starting to protest, and then, to quote Bobby Kennedy, they build up a wave that can sweep away the greatest walls of oppression and resistance. So just never give up. Sure, legislation is part of the goal, but everyday people protesting, saying we're not putting up with this nonsense any longer, is incredibly powerful.
Yeah, I guess what is very helpful for me, and especially in this situation, is that the community wants this law and is asking for it and pushing for it, which makes it so much easier to implement. And so I guess kind of what Christopher was saying is protest does help, and it allows the folks who are in the room writing the laws or litigating the laws to say, like, hey, I'm not standing alone here. Look at all these people who are wanting this. And so I guess I took your question to a very narrow, like, how do we support attorneys who are doing this work? That is that helps a lot. I would also say be willing to be plaintiffs. If you see environmental harm and I mean, in the U.S. especially, you still have to link it to your person. Hopefully not for too much longer, but be willing to be plaintiffs. Be willing to find those environmental attorneys out there who want to bring these cases. I know I've worked with NRDC and Earth Justice, and they don't charge. You know, they're pro bono attorneys who are willing to represent folks who are suffering harms when the environment is being polluted. And so, you know, take that step and be brave and do that. So that's what I'd suggest.
One of the questions I had is that many well-meaning laws can end up having devastating social consequences. So, for example, historic preservation laws have, spurred gentrification and have displaced communities of color. Conservation laws have done very similar things, kept people out from moving into certain spaces, and we have a history of that in the Bay Area with both of those types of laws. So I'm wondering if you've thought through some of the social consequences, possible social consequences of some of these rights of nature laws, and I'm just curious what some of those might be.
Thank you for your question. Actually, that was the first reaction of the Colombian government to this case. So now we have to prosecute small farmers and indigenous communities who are cutting down the trees because they need to survive. So the thing for us has been to try to explain that rights of nature is not a threat for vulnerable communities who have also their own fight, but it is like a tool that can complement those fights. And that has been the challenge in the implementation of this case, because the government wants to show that things are changing, and the easiest way is to go after vulnerable communities. So we kept speaking up and saying that this can be a tool for those communities to protect their own land, for indigenous peoples to translate their traditional beliefs in the language of the law. So that has been a challenge in Colombia, and we acknowledge that, and we try to find new ways in which this decision can be implemented without harming these groups. But that's a challenge.
I think when working with Native nations, it's important to ensure that laws are coming from a common understanding or a root of connection with the land. And so I can see how it's the difficulty with other environmental justice communities. There are times when that is in conflict, when Native understandings and protection of land is in direct conflict with other environmental justice communities, and that is a hard balance, and something that should be considered. And I don't know if I have an answer for you in that, but something that we are hearing right now is a lot of farmers rely on water from the Klamath River to irrigate their crops. And how do we balance the use of water for agriculture, the use of water for fish, and then just the idea that the river should have water for the river's sake? Those are conflicting rights and desires and uses. And so trying to find a balanced approach with that, I will agree, is very hard. And we always just try to tie it back to the idea that the environment should be in abundance, and the ecosystem and the species and the people who rely on it should all have that co-benefit. But yes, what is the actual answer? I haven't been able to find it yet either.
And prudent stewardship of the environment means there will be losers. In my country, we have over-dairying, and water systems, aquifers, are being seriously harmed by virtue of that. Whether people like it or not, we're going to have to cut down the number of cows we have in our country. We have too much dairying. And so there will in this kind of discourse be losers, but that is the price to be paid if we are to be sensible and prudent stewards of the environment. Luckily I'm retired, I can say that now.
Yes, thank you so much. I just want to echo everyone else in the audience by saying that this was a very, very powerful, very clear, and very inspiring set of presentations, and I've learned so much. I want to ask a question that I guess echoes some elements of Jeffrey's question. He asked about effects, and I'm kind of interested in the sources side of that story, because I work in sort of a different field and kind of look at how people from non-Western sort of cultural backgrounds engage the notion of rights. And there are aspects of the rights tradition that, of course, have kind of a neo-colonial or, even if not in effect or in intent today, but in their sources, there are aspects of the rights tradition that emanate from Christian natural law. He mentioned the Jesuits, or that emanate from sort of the Enlightenment tradition of the ontological individual and as the rights-bearing entity. I was just kind of curious, in the process of your various negotiations and your engagement of indigenous sources, how do you kind of navigate that tension between rights that don't emanate from those sorts of ethical sources? I'd be very curious to learn more about those conversations.
I think that's one of the reasons why I took you through some of those early works, starting with Salmond and the 1925 case and so on, because when you drill down, you can find that Anglo-American law can provide some answers, but you can actually make the indigenous people's view of things actually be something that can be properly legislated for. So I actually think if you're prepared to use use your brains, you can actually get to a solution that's compatible. I know that when we were drafting the legislation for the Wanganui River settlement, the parliamentary draftsperson had a great deal of difficulty bringing into the legislation, if you like, non-Western concepts, but she was very good, and it wasn't beyond her wit actually to achieve it. So the point I'm trying to make is, yes, I hear exactly what you're saying, but such as the flexibility of our, if you like, the common law system, I'm not qualified to speak about the civil law system, you can actually bend it to achieve your aims.
Yeah, I think your question's very interesting and something that we've been grappling with while we're developing this law, because essentially the Yurok people have always said that the Klamath River has rights, and that's just how the governance of the tribe has always operated since time immemorial, pre-contact, currently. The Klamath River always has had its rights, and everything ties back to the Klamath River. And if you do an action, any action you do is supposed to be within that river system and for that river system. And so the idea of writing this law, I think the biggest pushback we're getting is like, why do we need this law? Because this is how we are already. Like, this doesn't make sense to put it in a Western law box, because this is how we are as a people. And so when I explain why Tribal Council wants to codify the rights of the Klamath River, it's not because the Yurok people don't view the river having rights. It's because we are in today's reality where the tribe as a government entity and the Yurok people as individuals are being limited by federal, state, and local actors, Western legal actors. And so we need to develop a law that will allow us we need to codify and develop a law that will allow us to navigate this Western system while also strengthening and enhancing Yurok, I guess almost common law. Like, I guess that's a good way of saying it. Like, that's not the terminology that the Yurok people use, but to put it in Western terms, the rights of the Klamath River is a common law that we are now codifying so we can better navigate the realities that we are facing right now. And then going, I guess, a step further, we're trying to develop this law so it's very future-looking when that Western system relaxes a bit And when Yurok common law has more authority in Western-style courts and Western-style administrative proceedings and other legal forums, and so we can assert more Yurok jurisdiction in the future. And so it's kind of this weird game we're in right now. It's like, this is today's reality, this is where we want to be in the future. So it's a bit of a balancing act there.
I'll just add, because I think Geneva captured it really nicely, conversations that we have had with like the indigenous delegates to Ecuador's Constituent Assembly. Very similar conversation with tribal nations as well here in the US. And I think it's absolutely right. It's existing in today's legal reality and beginning to capture worldview, relationship to Mother Earth and Father Sky in written Western, what looks like Western law, but using that kind of law to be able to put into words in a way that's legally enforceable how their relationship and their cultural, historical, ancestral relationship with the land and the water in a way that they can enforce and defend it, that not having it in written law doesn't allow.
I would add, I remember a conversation I had with an indigenous leader just after we won the case. And when we did this presentation and explained who was each of the plaintiffs, he told us, you needed to do all this. You needed to go to different judges and do research on climate change. It's an act of translating what other communities and groups already know.
Thank you to the panel and to Dana for organizing this panel. This has been a great discussion. It's such an honor to have, you know, people who are at the cutting edge of this Rights to Nature movement to be here at USF. So thank you for coming, and thank you, Dana, for organizing this. Professor Pollard stole my question, so I'll move on to my second question. It's a bit conceptual, but I'm wondering which natures have rights. And let me kind of and I'd love to get the panel's opinion on this. Thinking about, do the invasive species in the river have rights? There's a lot of rethinking about non-native and invasive species right now in ecology, about whether they should be there, whether they shouldn't be there. At what time scale do you think about in terms of nature, in terms of restoration or non-restoration of ecosystems, how that plays into the nature rights framework? I'm thinking about new biotechnologies. Do the genetically modified crops that we have, do those have rights? They're natural and they're nature embodied, they reproduce. So what are the limits and what types of natures come into this framework, and how does this framework kind of deal with some of those tensions?
Well, I'll start. Thank you for your question. I won't talk about the technology because I don't understand it. But I can tell you this, which is every community, every people, every place that we work, we consider ourselves facilitators and educators around this work to help people to write the law that they need and want. And generally what that has meant is either laws that recognize rights of nature as a whole, such as in Ecuador's constitution, rights of a particular species, such as the White Earth Band of the Chippewa Nation, which we work to draft a law and pass a law that recognizes rights of Monoman, which is wild rice, and that talks about native natural species. That's the first law to recognize rights of a particular plant species. In other places, it's focused on a particular ecosystem. And as Geneva was talking about defining that ecosystem, so when we can vary, with regard to like a river, for example, one could say, oh, that means the water in the river, but the definitions of a river ecosystem and other ecosystems are much broader than that. that it's not just about the water, literally, that's flowing through the river channel, that it's about a broader ecosystem, the watershed, that river needs to be healthy in order for the river itself to be healthy. So there's ways to define what that nature is, something that's just nature on the whole, or a particular ecosystem or species. I can tell you that the laws that we have worked on that have included specific mention of species have focused on native species. And you see in different jurisdictions that there are already laws that relate to things like GMO or non-GMO and whether or not those are allowed anyway. So those are sort of taken care of, if you will. In places like Ecuador, they have that. In some of the EU countries, they've already dealt with GMOs in their laws, and so they've already, in some ways, created prohibitions that a rights of nature law doesn't have to address, but it certainly could. But I guess the last thing I'll say about it is it really, I think, very much depends upon the people on the ground who really are the experts about the place where they live, the species that they live with and depend upon, the ecosystems, the water, and so on, to define what that law needs to look like in order to protect that place. And so those laws can look different, but I think largely what they're focused on is protection of natural systems. Natural systems as we understand them, a natural ecosystem, a natural species population, and protecting those natural systems so that human activity doesn't interfere with the ability of a natural system to have health and well-being, to perform its natural function. Basically, so that we're not interfering with an ecosystem's not only right to, or a species' right to exist, but its ability to be healthy and robust and provide for all of the critters and creatures, including us, who depend upon it.
That's an excellent question, but I think has to be protection of the natural system. In my country, for example, the early settlers decided that it would be wonderful if deer and rabbits were introduced to New Zealand, and when the rabbit population exploded, they thought it would be an excellent idea to introduce stoats and weasels to get rid of them, and that population exploded. I'm certainly not here, nor would any rational New Zealander be here to argue that stoats, weasels, and rabbits have rights. It has to be the natural system. And if it means that invasive species have to be dealt to or dealt with, then I think that's part of the equation.
Yeah, so I think this is a question that we are grappling with right now as we're navigating this process. I'm actually working really closely with our natural resources departments to define which aspects of nature are included under this law, and that is difficult to figure out. When I first got this assignment, it was supposed to be to dedicate the rights of salmon, and we were going to go just like a singular species route, probably because of this this broad question of like, what do we protect and what we don't. But as I was moving forward in all of our committees and talking with all of our elders, they're like, but what about the sturgeon? What about the seaweed? What about, And so it got to the point where everyone wanted a rights of X species law, and I was going to be drafting like 25 laws, and I was like, y'all, that's a lot. And so we moved to this idea of the rights of the Klamath River, so it can be all-inclusive of all of the culturally significant species. And in this law, we're definitely focusing on not only the river itself, but the species that have direct ties to Yurok culture as a way of tying that to, these are the species that are naturally supposed to be in this ecosystem. Because the Yurok people have been here since time immemorial, have been living in relationship with these particular species. These are the species that belong here and that should be thriving here. going specifically to the question about genetically engineered organisms, actually the Yurok tribe has a law on the books before I even started working there that genetically engineered organisms are not to be in the Yurok environment. And so this was a direct response to the idea that folks were trying to figure out how to genetically modify salmon that could survive in rivers that are dammed. And the Yurok people are just like, we're not having that. Like you're going to decimate our naturally existing salmon population that we rely so heavily on. And so that one was a very clear thing to put in this law because that's already on the books. It's interesting to figure out which species to focus on and which ones not to. I know right now folks on the river are saying that there are new species coming up past the estuary as the climate gets warmer because the river's ecosystem is now adapting to be more inviting for these species. And the big debate right now is, are these invasive species or are these species trying to survive? And what should we do as a government in looking at that? And what is our role with these species? And what do we want to do moving forward? So it's a big open question. And I don't know, maybe we'll have a case where we litigate that and try to define that more through our judicial system. So, but yes.
I think that there is no formula, a correct answer for that question. What I have seen from the Rights of Nature movement is that each case is particular and it is different, and the limits are set by the judges or by the Congress or by the citizens themselves. So in our case, the limits are the natural system that is the Amazon rainforest, but it also includes the communities that inhabit that system. And we'll see if maybe in the future someone files a case on behalf of the Amazon. But for me, it is a creation that's evolving, and there is no final answer. We are trying to resolve what this means by doing it.
I have a question. My question is about sovereignty. Oftentimes, when we talk of land rights or the rights of nature, we often, especially in global south, we often see that there's a conjoined aspect of self-determination and the rights of the indigenous people to protect their land. So what are the limits when it comes to who loses and who wins in those aspects?
Well, that's probably a question that's more directed to my North American colleagues than me. In my country, by virtue of the treaty I told you about, although there are some tribes that dispute it, sovereignty was transferred to what is now known as New Zealand. But within that, tribes should be able to have the maximum degree of self-determination. So, for example, I know that the Tūhoe people, for example, would very much like to have all unemployment benefits paid directly to them, and they will employ the young people to make sure that no Tūhoe young person is ever on the benefit. So within the context of sovereignty, you can actually design things that will give the indigenous people maximum rights of self-determination without getting into what I think ultimately are somewhat arid and pointless arguments about whether or not at the time the Treaty of Waitangi was signed, various tribes decided not to cede sovereignty to the British Crown. But that's a New Zealand response. Of far greater moment will be the commentary from my North American colleagues.
I think your question is right on point, because we see, and we do workshops on Indigenous rights and the rights of nature, we see those as very integrally related. Our ability to be sovereign, to have self-determination, inherently means our ability to protect the place that we live and depend upon. And too often, so often, as we know with tribal nations, in North America, First Nations, and in other parts of the world, Indigenous peoples don't have a meaningful level of self-determination. And so much of our work, I mean, our organization focuses on democratic and environmental rights because we think those two things go hand in hand. You can't have one without the other. And so often we are having that conversation and talking about how do we shift, like a tribal constitution, for example, so that it begins to reflect their ability to decide how to protect the place that they need to protect, authority they may not possess. And so for us, often the laws that we draft both establish a right to decide, a right to self-determine, and the rights of nature at the same time. Because again, we see those very much going hand in hand. And so much of the conversation that we have isn't even about the environment. It's about who we are, who they are, and their ability to self-govern, which is both an Indigenous deep concern, but also for non-Indigenous communities that we work with in the United States. I mean, I use the Florida example where you have communities right now are being told in Florida that they don't have the right to self-govern, they don't have the right to protect the environment, they don't have the right to protect nature. So they're questioning their, whether they have democracy in their community. And so I think the fight that they're going to end up having is going to be much more about democratic rights than it's going to be about environmental rights or rights of nature. So my point is that I think your question highlights one of the key issues around the environment today, which is that people literally don't have the authority to protect the places where they live. And the rights of nature is really about expanding that right to make that decision. And one of the other ways, I don't think I mentioned it in my earlier remarks, but one of the other ways that rights of nature laws differs very much from conventional environmental laws is that we look to government today to do the right thing. And I'm not just talking in the United States, everywhere we look to government, and laws very often centralize authority to a government and not to people. Rights of nature laws really developed with an understanding that when our governments fail to do the right thing, that the people need to have the authority to be able to do the right thing, which is why the first rights of nature laws have specifically empowered people to be able to defend and enforce the rights of nature. And you see that at national level in the Ecuador Constitution, you see it at the most local level. And I think that's going to be really, really critical going forward as well.
I think my biggest role as being an Associate General Counsel for the Yurok tribe is actually defending the Yurok tribe's sovereignty and right to exert jurisdiction, whether that be through, the most boring contract or through developing, the rights of the Klamath River. And so this is something that we think about a lot on what are the limitations put on us by outside powers, and what are the inherent sovereign rights that the Yurok people have always had, and how do we remove the barriers put in place by foreign powers being the United States and state governments, and how do we strengthen the inherent sovereignty of the Yurok tribe to its fullest capacity. And that is always it's a push and pull kind of thing, and you can just see throughout the Yurok tribe's history where, pre-contact, the Yurok tribe was the government of the area and, exerted all control and jurisdiction over their ancestral territories. And that has, at one point, the Yurok tribe was deemed non-existent, and no one recognized the government. At another point, they were put under some other government, and now, we're here where we are today. And so it's always in flux. And the fact that the inherent sovereignty, but also how the U.S. government recognizes sovereignty, how that's always in flux actually gives me a lot of hope, in the sense that it's never stagnant, and we can continuously push on those barriers, and we can continuously push on those foreign powers that are trying to diminish indigenous sovereignty. It's kind of it's an exciting, hopeful thing that I think a lot of people are excited to develop more. It's probably why I went into this area of law, because it's always shifting and always dynamically changing, and I don't know, it's quite a thought process. And so it's exciting to talk about it with you all.
Okay, well, we are out of time for tonight, so I just once again want to really thank our panelists for traveling all this way and for sharing with us the work you do and are continuing to do. And I'm very hopeful that, a year from now we can reconvene and talk about successful implementation of some of these rights of nature laws, and that things have progressed forward, not just here in the United States, but elsewhere. So if you could join me once again in thanking our panelists.